What's the consequence of a judge erroneously allowing in scientific evidence? To find out, you have to read People v. Easley, but it's 12 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on the case of People v. Easley, published by the Court of Appeals on April 26, 2022. The citation to this case is 2022 New York Slip Opinion 02770. I include a copy of the decision in the description. The issue in this case is, what is the consequence of a court issuing an erroneous evidentiary ruling regarding the admission of scientific and expert testimony? To understand this case, you have to understand two things: the Frye hearing and the harmless error rule. A Frye hearing in New York is a hearing that has to be conducted whenever expert testimony is sought to be introduced that is new or novel in some way. Because expert testimony has to be generally accepted in the scientific community. If it's not if there's a challenge to expert testimony, you have to have a Frye hearing to determine whether or not the testimony sought to be introduced is generally accepted. The actual test is, are accepted techniques, when properly performed, generating results which are accepted as reliable within the relevant scientific community? If so, it passes. If not, it fails. You can't basically have a quack doctor come in and say, I've invented a machine that when I press this button, it tells me if the defendant ran the red light. Unless that's been peer reviewed and accepted as reliable, you can't have that kind of testimony or evidence come in. But then there's the harmless error rule, which is codified under CPLR 2002, which says that an error in a ruling of a court, so if a court makes an error, it shall be disregarded if a substantial right of a party is not prejudiced. So it's kind of like a no harm, no foul issue. If a court makes a mistake, it's not an automatic reversal unless it substantially affects and prejudices a right of a party. So what are the facts of this case? The facts are, there's a fight inside of like a deli or a store, and there's a video camera that captures the whole thing. 6 people, 6 guys are surrounding the defendant and attacking him. And someone calls the police, and when someone calls the police in the store, the defendants scatter. But the video camera shows the defendant, allegedly, according to the majority opinion, take something and put it on the store shelf. And the video shows that when the police arrive about 2 minutes later and they look on that shelf, they recover a gun. The defendant is charged with criminal possession of a weapon. They send the gun for DNA testing at the OCME, the Office of the Chief Medical Examiner, who does DNA testing in New York City. And the results are inconclusive. They don't determine one way or the other in the normal test. So the OCME uses its special new test called the LCN FST test. It's a Forensic Statistical Test. It's different technology, different analysis, where they basically take, and I'm not an expert here, they take a smaller amount of DNA, they duplicate it many times, and it comes up with a result that's not the same result as the normal PCR test. The result that they come up with says that there's 3 contributors, and it's 4.57 million times more likely, that one of those contributors is the defendant than that all 3 people don't include the defendant. The people take this testimony from the forensic criminologist and the officer's testimony at trial, but it's important to note that no one sees the defendant holding a gun. No witness sees the defendant holding a gun. There's no fingerprints recovered, no blood. And essentially the jury finds the defendant guilty. The Appellate Division affirms it. It goes to the Court of Appeals and they say wrong. The judge was wrong. This was an error to not have a Frye hearing when it was requested by the defense. But the majority says harmless error because the evidence was overwhelming. You can see on the video the defendant take the item, put it on the shelf. Police recover that item. It's the gun. So the evidence is overwhelming, and there's not a significant probability that the jury would have acquitted the defendant if the court had not committed that Frye hearing error. But there's a strong dissent by Judge Wilson, Judge Rivera, and Judge Troutman, where basically they say, yes, it's an error. Everyone agrees it's an error not to have conducted the Frye hearing, but not a harmless error. Because no one saw the defendant holding a gun, and they reiterate the test and say it's a 2-part test for harmless error. 1, the evidence of the guilt must be overwhelming, and 2, no significant probability that without the erroneously admitted evidence, the jury would have reached a different verdict. And they say that 4.57 million number had a reasonable possibility or probability of affecting the jury's verdict. And that could be why he was convicted. It's not just that it's overwhelming without that. And so they would reverse it. And that's the case of People versus Easley. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.